All right. Well, thank you, everybody, for joining us. This is Matt Morton with the Parkinson Foundation of Oklahoma. Tonight, we've got two great guests, Laurel and Riley Kern of Tallgrass Estate Planning. I've known them for a while. They do a lot of great work to help people across all walks of life put things together like power of attorney, revocable trust, will and testament, and things like that. But also for the Parkinson's population, special things in particular, special needs planning, medical asset protection planning, all these types of things, that you may run into down the line. And so we're going to have a quick session with them. And if you guys want to introduce yourself, I'll hand it over to you, kind of talk about who you are, what you do, where you're at, and how you can help everybody.
Thank you very much, Matt. So we do a lot of Zoom presentations, and I will lay out a couple of things maybe that would be some advice for how to move forward in this conversation as efficiently as we can. We're not going to take some time up front to do some questions because we want to get through some important information. Those of you who are able, we're going to have the chat window open so that if you can chat some questions along the way, please feel free to put them there, and we'll either address them as they come up or we'll wait till we kind of hit a stopping point and address them there. If for some reason you have difficulty typing or creating a chat like that, feel free to unmute yourself and stop us and just say, hey, can I interrupt with a question? And that's totally fine.
And I think we're going to be having some questions our time at the end as well, so.
So I'm going to share our screen real quick. I think you'll still be able to see our faces in the chat window. And after all, that is incredibly important because we are beautiful, beautiful people.
Why do I need to see it? I can hear it all. Okay.
There we go. Can everybody see on their screen a slide presentation that just has a planning logo on it? Okay. On the bottom of most of these slides, there's going to be some contact info for our firm. Laurel, in just a moment, is going to introduce our firm and kind of what we do. I want to take just a quick second to introduce the topic and talk about what we're going to look at today. So there's a lot of different things we could talk about with groups like yours. One of the biggest, the most frequent questions we get asked is if somebody needs to go into skilled nursing, are there ways that we can make sure that assets and savings and retirement accounts, those kind of things are saved to supplement your care as long as possible rather than having to go broke, right? This is kind of the biggest fear that people have is you've spent your entire career working for your IRA or your 401k, paying down your house, and then you're afraid that just because of a chronic illness that might be lost. So we're going to talk about some ways around that, and we'll also address some basic things like powers of attorney and guardianship along the way.
And I'm just going to quickly introduce our firm. So Tallgrass Estate Planning is me and Riley in the beginning, right? We're both attorneys, we're married, that's why we sit so close to each other. We also have, we're in Tulsa, and we go to kind of all surrounding areas. We also have an attorney in Oklahoma City. All Tallgrass does is estate planning, and that includes everything from, revocable living trusts to adult guardianships, powers of attorney, probates, all those things. Go ahead.
Well, and we handle those things statewide. So yeah. We are based in, our offices are based in Tulsa and Oklahoma City, but we've got clients in Bartlesville and in Stillwater, down in Durant, the southwestern, southeastern part of the state. So we go all over.
Yeah. Okay, so I know our time together is kind of brief, so I'm just going to kind of start talking about things. Oh, well, there we are. I forgot about this. Hello,
yeah, this is the team. So Laurel and I are the founding partners. We've got another attorney and then some support staff to really help make sure that our clients kind of get their needs met and communication happens as efficiently as possible.
Okay. So, as estate planning attorneys, we're helping people at all stages, right? So people who are later in life, people who have a specific concern, like long-term care costs. We have younger clients that are coming to us thinking about their kiddos. And so really every single person needs an estate plan. And the most common question is, if I have nothing else, what do I need? And this is our answer, right? You need to have a power of attorney. It really doesn't matter what your situation is. You need to have a power of attorney. So I'm going to talk a little bit. Okay. sorry, you know how you know the information, but then you forget how you prepared to talk about the information. So I apologize if sometimes I get ahead of myself. So, a lot of times when we're starting to help folks that have been married for a long time, they're thinking to themselves, we're married. I'm going to be able to help my spouse if something comes up, right? We jointly own our bank account. And if there's any need to access assets or to pay the mortgage, I'll just be able to do that because I'm married to my spouse. That's actually not true, right? So you're actually going to need something that gives you the authority to help that person. And, we have spouse up here, but this is true if it's your adult child, whoever it may be, that's helping somebody make decisions, manage assets, that kind of a thing. They need the authority somehow to be able to do that.
And that's critical, especially because we're going to be talking in a moment about some advanced planning techniques. And though you and your spouse may have been able to do some things with and for each other right now as joint owners, if one of you becomes incapacitated and you need to do some advanced planning to help them qualify for certain benefits or protect certain assets, you're not going to have the legal authority to do that just because you're married without some of these documents we're going to talk about.
Right. So we're going to get that kind of help in one of two ways, either through a power of attorney or a guardianship. And I'm going to talk to you a little bit about what those two things are. They can give similar authority to do different things, but they are not the same thing. So normally, if we were here in person all together, I would encourage you and invite you to really think through these differences and ask you questions that would encourage that. But as we're in the Zoom world, I'm not going to force you to do that, right? So the difference between a power of attorney and a guardianship. Okay, so a guardianship is going to be a court-controlled process, right? If somebody comes to me and they together determine that a guardianship is going to be the most appropriate thing, I'm going to help them prepare a lot of paperwork, and then we are going to go file it with the court. We're going to have a hearing. The court is going to grant guardianship, right? So you're getting that authority through the court giving it to you, okay? A power of attorney is a different situation. So a power of attorney is, gosh, there's so many differences, but anyway, you could come to me today and say to me, oh my goodness, my husband is about to go in for surgery. I'm a little bit concerned about what happens if he's, out of it for a couple of days and I need to manage his assets or talk to the bank about the mortgage, or he forgot to put me on the utilities, something like that. And I need them to be able to talk to me. What do I do? We can do a power of attorney, right? A power of attorney is I give somebody else the authority to help make those financial decisions, okay? And it can be, I'm talking about a spouse, but it could be anybody. It could be an adult child. It could be a friend that you trust. It could be whoever you would like to have that authority to help out, okay? You might have kind of picked up that it's a really quick process to do a power of attorney, right? You come to me this day and you tell me that this is what needs to happen. And as we're talking through it, I can sit there and draft while we're talking, right? And then have that ready for you to sign, okay? Because of how quickly I'm able to do that, and it's just, you and me, and then our notary is gonna come in, we're gonna have a couple of witnesses, and we're able to do it that day. It's going to be fairly inexpensive as compared to a guardianship, right? I was kind of sketching out a little bit what that guardianship process entails. There's quite a few pieces of paper that are going to need to be filed. We're going to need to send statutory notice, and then we're going to need to appear in court. So that's going to take more time. That means it's going to be a little bit more expensive. I just mentioned that we're going to need to send statutory notice out to people. That means that we're going to invite people to come in and say, hey, I don't agree with this. I don't think that my husband, this guy, should have guardianship over her. That seems like a terrible idea. He's bald-headed, and bald-headed people never make good choices. Now that's a silly thing. Usually there will be larger concerns, maybe that they doesn't spend money very well, and I'm worried about that.
substance abuse problems, those
Yeah.
kind of things.
Those kinds of things.
So Matt, if some of you may or may not have your chat window open, I would encourage you to open it up to see some questions, but Matt just asked a great one. If guardianship is so complicated, then why do people do it? And the answer, Matt, is because they don't have another option. If you don't have a power of attorney in place, your only option to get this authority over somebody that needs the help is guardianship.
And that's why we say, if you have done no other estate planning, what I really would encourage you to do is to get that power of attorney in place. Because otherwise what's going to happen is we walk along to a crisis moment and guardianship is our only option.
We don't want to have to rely on court-controlled processes if we can avoid it. And the simplest way to avoid it during incapacity is to make sure you have already, while you're healthy, have signed a power of attorney naming who you want to have this kind of authority to help you financially and medically. Now, the other thing, we don't have a slide about this, but I want to be clear, not every power of attorney is created equal. We see a lot of institutions and government agencies that deny powers of attorney that leave a lot to the imagination. If they are not thorough and detailed, they will probably get rejected. So if you're going to create a power of attorney, work with somebody who knows what they're doing. Don't just download some form off the internet and expect that it's going to do everything you need it to do, especially when it comes to helping someone do some asset protection planning and qualify for government benefits. Okay.
Yes. We did ourselves. Okay.
So the reason we're talking to you about this particular topic tonight is because people sometimes don't understand the scope of what's at stake if one spouse or partner goes into a nursing home. What is likely to happen next? How much is that going to cost, and what kind of assets are you going to lose? And so I want to start, before we talk about some solutions to qualify for benefits, I want to get clarity on what the problem is. So Oklahoma, of all 50 states, has the lowest average cost for long-term care. But even with that, at an average of $48.67 a month, and that includes both public beds and private pay beds. So we're talking about $58,000 or almost $60,000 a year. Those are numbers from 2019, pre-COVID. My suspicion is that the cost of long-term care in the last 2 years has not decreased, but has increased. So $60,000 on average is the cost of long-term care if we're talking about skilled nursing. So if you turn 65, this is just for everybody. We're not controlling now for people with chronic illnesses like MS or Parkinson's. If you turn 65, there's a 70% chance you're going to spend time in long-term care. The average long-term care stay right now is about 835 days, which means most people over 65 are going to spend at least $133,000 paying for long-term care. That's a lot of money. Okay. And it's money that could be protected if we do some fairly straightforward planning ahead of time. So we're going to talk about how that functions. What if you haven't done any planning though? What if you are in an emergency? You've always thought to yourself, I'm not going to need long-term care, or that's still a few years away. I've got plenty of time, and it sneaks up on you. We've got clients like that we work with every month who come in here and they thought they had time. And now one spouse is a healthy spouse that's planning for a disabled spouse who's going to need long-term care. If you are trying to qualify for benefits like Medicaid to pay for long-term care, but you've done no planning, then you have to pass 3 different tests. One of them is you have to meet certain medical qualifications. We're not going to spend any time talking about that. That's pretty straightforward. If you don't need the care, they're not going to give you Medicaid to live in a nursing home. So you need to have an actual medical need. But the other 2 where this gets tricky is you have to meet certain income qualifications. If you have too much income, you don't get Medicaid, and you need to meet certain asset qualifications. If you have too much assets, you can't get Medicaid. So what are those tests? Let's start with the income test. And again, if you've got questions or if I'm going too fast, please feel free to put them in the chat window and I want to stop and address them. Okay. So in 2021, current law is that if you have more than $2,382 a month in income, we're not talking here about a distribution from your IRA. We're not talking about certain tax-free benefits, but if it's earned income, a pension, Social Security, those things all count as your income. If you have more than 2382 and you have not done planning, you are not going to meet the qualifications for Medicaid. If you are married, your spouse can have at least what's called a MIMNA, or a monthly maintenance needs allowance. Your spouse can have at least $3,260 a month in income. So let me give you a quick explanation of what that means. If I need long-term care and I have $2,000 a month in income, and my wife can stay at home and take care of herself, but she only has $2,500 a month in income, she can take another $760 a month from me to get her up to that $3,200 mark. And I'm still under the income amount. I can get Medicaid, and she can actually borrow from my income as the well spouse or the community spouse to get her up to at least $3,260 a month. But her income doesn't count against me. If she makes $10,000 a month, I'm still under the income limit at $2,000 a month. She can have as much income as she wants, and it doesn't count against me. But if she has under $3,260, she can borrow from me to get herself up to that. Does that make sense? Okay. So that's the income side without planning. What about the assets side? So you have income, that's the regular monthly money that comes in, and then you have stuff like your savings and your house, that kind of a thing. Well, if you are an individual who needs long-term care, you can't have more than $2,000 to your name and qualify for Medicaid. So you in other words have to spend down all of your assets to $2,000, and then you can, once you're broke enough, you can get Medicaid. If both spouses need long-term care, then the government is much more generous, and you get to have $3,000 total in your name before you qualify for benefits. Now, again, what about the community spouse? What if I need long-term care, but Laurel doesn't? Well, she can keep half of our joint assets up to a maximum of just over $130,000. So by the time most people reach retirement and they've got some money saved, $130,000 is not a full half of their assets. They've got to spend down quite a bit just to get the community spouse to that amount, so that the other spouse can get Medicaid.
Because so something like an IRA is counted in those assets, right? We basically are looking at, so a couple will come in and we ask them jointly, you know, what are your assets? What are your assets? We add that all together, and then we cut a line in half, and we spend community spouses down to 130. And then the spouse needing long-term care goes down to the 2,000.
So that includes, you know, my wife's income may not count against me, but her 401k does, her IRA does, right? So your spouse's separate assets in that sense are still counted against you for Medicaid purposes. And even the spouse has to do a spend down oftentimes. Again, the situation we're talking about here is when there has been no advanced planning. When you're coming in a crisis, how do we get qualified? Now, if one spouse can still live at home, the house doesn't count against them. So if you have a house that's worth $300,000, that's not limiting you from getting qualified because the other spouse can still live there. But if you're single, then the value of your house does count against you. You got a $150,000 house and you're single and need long-term care, you need to sell the house, spend that money down to $2,000 before you get benefits. Go ahead, Laurel.
Okay. So I'm going to talk a little bit about some of the planning strategies. I will say that there are more than what we're going to talk about tonight, but we're kind of trying to cram as much information in 40 minutes as possible. So we're kind of hitting the high notes. One of those that people have maybe talked to you about, or maybe they haven't, is something called a Medicaid Asset Protection Trust. Okay. I'm sorry. So qualifying by planning. So long-term care insurance is fantastic. If you can afford long-term care insurance, that's great. The truth is most people do not have long-term care insurance. And by the time it occurs to them that maybe they would like it, the premiums are so significant, it actually really doesn't make sense to them to do it anymore.
If they could even qualify.
If they could even qualify, yeah. So then if we're trying to plan, right, then we're going to think about look ahead planning, which is what I was referring to briefly, the Medicaid Asset Protection Trust. And then Riley is going to talk to you a little bit about a different strategy. Okay. So when we're thinking about trying to qualify for Medicaid, right, we're thinking my spouse might need long-term care, or I might need long-term care. I have been paying into Medicaid for my whole life. And I would like it to go ahead and at least have the option of qualifying for Medicaid if I need long-term care, right? So we talked a little bit about what the rules are, the tests that you're going to have to meet to be able to qualify. One of the things that has sometimes occurred to people over time to do is, oh, okay, well, if we can only have $2,000 in assets and $130,000 in assets, maybe I should just give some of my stuff away, right? You might have thought that yourself just now. Yeah, right. So Medicaid has kind of gotten wise to that. For a while, they had something called well, it's 3-year look back period, but now they have something, it's a 5-year look back period. And what that means is they, when you're trying to apply for Medicaid, are going to ask you to provide 5 years of bank statements and to basically answer questions about what have you transferred away from yourself for less than fair market value in the preceding 5 years, right?
That could include even like birthday and Christmas gifts to the grandkids of, you know, 50 and $100. I mean, it could, or larger transfers like giving the family farm to the kids. So.
Yeah, we actually did have a client and their spouse was in a facility and they had, as you know, grandparents been giving every month a little bit to the 529 for their grandkids. And because they had quite a number of grandkids, it ended up being about $1,000 a month. And so the social worker they were working with is like, tell me what you've been doing with this money. You know, are you trying to intentionally, you know, move your assets away from yourself? I'm like, no, it was all part of, you know, this planned giving that we'd been doing for X number of years. Anyway, the point really there is they're going to look at those bank statements and anything that looks like you giving assets away from yourself for less than fair market value, they're going to ask you pokey questions about. So
we even got I was going to say real quick, we have a client that we met with this morning and I spent some time talking with this afternoon, who she has Parkinson's and is a member of the community here in Tulsa. She's got 2 adult children. Over the last few years, her adult children have done certain things to help her as she's lived at home, like, you know, go buy groceries or run her back and forth to doctor's appointments. And the mom has done a normal thing, which is every once in a while, she'll give the daughter some money and say, thank you for being so helpful. Well, we'll talk about how to solve this problem in a moment, but even giving some money to your children in exchange for some of their services can sometimes be considered a penalizable transfer. So we need to be really careful with this 5-year look back period and how it could create a penalty before you could qualify for Medicaid.
Yeah. Okay. So what I was starting to talk about too soon, the Medicaid Asset Protection Trust is a way that we can do advanced planning if we have a long enough view. Okay. So we're going to use Richard and Susan. They like to take photos, black and white photos, I guess. But anyway, so we're going to use them. These are probably the folks that are thinking about doing a Medicaid Asset Protection Trust. And truthfully, it doesn't have to be a married couple. It could just as easily be a single person. But they're probably healthy, or at least one of them is healthy enough that they think that they are not going to need long-term care in the next 5 years. Okay. They are thinking about, you know, we're getting a little bit older. And we just, if one of us does happen to need long-term care, we would like to have the option of qualifying for Medicaid and maybe having put aside some of our assets So they create a Medicaid Asset Protection Trust. What is that? Okay, that's a great question. I'm so glad you asked, right? So there are lots of different kinds of trusts, right? You may remember from Downton Abbey, they had a complicated trust situation. There's all kinds of trusts. I'm talking to you about a very specific type of trust. It is an irrevocable trust. Because it's irrevocable, it's basically going to be like a separate person from yourself. Okay, so it's this legal fiction where it's like, oh, hello, nice to meet you, Medicaid Asset Protection Trust. It's a separate person. Okay, you are going to still be able to, in certain circumstances, you could still be the trustee of it, meaning the person that manages the assets within the trust. You're going to choose, you know, what happens to the assets within that trust after you're gone and you no longer need them. And you're going to choose what assets you want to put into the trust. Okay. Most of the time, people are thinking about putting in something like real estate, something that maybe stocks that they fairly recently purchased that have a pretty high basis already, moving that kind of a thing in there. Something that they're not planning to pull value in and out of all the time. So probably not a checking account. Okay. They put the assets in there. They do it well in advance. Look how healthy Richard and Susan are. They get through the 5-year look back period. And once they have done that, anything that they have put into that irrevocable Medicaid Asset Protection Trust, they're not going to have to report that value of the asset on their application when they're applying for Medicaid.
Laurel, let's say you a couple of years ago created a revocable living trust with your attorney for estate planning, and you think to yourself, well, I've got money in trust. Is your revocable living trust going to help protect these assets from a long-term care spend down?
It is not, no. So he's asking that question because it's a really common misconception, right? I have a trust, I have stuff in the trust. Is the trust that I have going to do what she just talked about? The answer is, we need to look at that trust, right? Because you have to draft the trust with the whole intention of it being that Medicaid Asset Protection Trust. Otherwise, if you've created what he just said, a revocable living trust, that is a wonderful tool. We do them all the time. I love them, but they're really effective for avoiding probate and then maybe providing some asset protection or shaping how assets are available for beneficiaries.
But they don't do anything to protect your assets from a long-term care spend down.
They do not. And then since I'm the one who's talking about trust today, I'm going to talk about this slide just really quickly. Some of you may have heard when he was talking about there are 3 tests that you have to meet to be able to qualify for Medicaid. One of them was the income test. And he said, Social Security and any pension that you might be getting. Oh my gosh, when you add those 2 together, for me, it comes to $2,500, right, per month. What am I going to do? Does this mean I can never qualify for Medicaid? No. There is a special kind of trust. It's often called a Miller trust. Basically, we run all of your income through that trust so that the trust is receiving the income and you are not. And that's how we end up allowing you to qualify for Medicaid if your assets are too high. Oklahoma does have a limit on how much income they will allow to pass through that kind of a trust. I think right now it's 5,300 and
5,600, yeah.
56, okay, 5,600. So there is a limit, but if you heard him say that and you got a little nervous inside, there is a plan that will work. It is a type of trust and it's called a Miller trust.
So yeah, if clients come to us and they've been told they've got too much income, we can shift a lot that direction and really help. So one of the things that we need to think about in planning and whether or not we need to move certain assets into a Medicaid Asset Protection Trust, or even if we need to spend them down in a to become eligible, is are those assets what are called exempt assets or available assets? So not everything you have or your husband or wife has or your parents have, not everything is going to be subject to needing to be spent down to get under $2,000. There are some assets that, depending on your situation, are automatically not part of that math. So an exempt asset is one that is not subject to the eligibility requirements, and an available asset is one that has to be spent or lost in order to become eligible. So some examples, some really common examples of exempt assets might be if you spend some of your money to pay for medical bills or acquire essential medical equipment, right? Maybe dad needs a lift chair in his room. That is an asset, and spending money on that asset is not going to be a penalizable transfer. Care management contracts with a professional care manager organization or home health care, or even a personal services contract with your family member. If you have a contract with your adult children to help you go back and forth to the doctor or run errands or get you groceries or cook you food or mow the lawn, and you want to give them money for that, so long as you have a contract that allows you to do that, that is going to be exempt as well.
And I just want to linger here for a moment because people do come to us sometimes and they're in a crisis moment. They tell us, our daughter has been awesome. She has been providing lots of meals for us. She makes sure that we always have the medication that we need. She, every Sunday she comes by and she sorts the pills and they're in the containers. So we have that for the week, right? Well, how long has she been doing that? Oh, well, for about 2 years. Wow, that is so great. If you guys had entered into a formalized agreement, meaning a written down contract, where she was saying what she was going to do, and you were saying how much you were going to pay her for doing that, then you could gradually give her money for doing that. You could pay her, right? Move assets away from yourselves to her in exchange for doing that. And then that wouldn't be within the amount that we're needing to report to Medicaid on the application.
But I know that sounds so strange. People say to us, well, I don't want to contract with my parent to get paid for helping them. I love them and I want to do this because I love them. Totally get it. This is not really about getting you paid. That's not the point. The point is it gives mom or dad or your family member, somebody, a loved one, a way to shift money from their own available assets to you to hold those assets as an exempt asset. So you can use that money for them. You don't need to take it and for yourself, but it gives them a way to take some money out of their own savings, short-term savings, and put it into yours so that it can't be counted against them. But if there's no contract, there's no opportunity to do that.
And the reason that I just wanted to linger here is because you need to do this before those services are given, right? You can't say, well, oh, for the last 2 years, she was doing this for us. I'm just going to go ahead and figure out what she was doing, how much time it took, and then just pay her, $20,000. You can't do that. Medicaid is going to say that is a transfer for less than fair market value. It wasn't done pursuant to this formalized agreement, and they'll ding you.
Yeah.
So you need to have this contract in place and then pay moving forward.
Whenever we're meeting with a client who's got a chronic illness, one of the first things we do is put in place a caregiver agreement with one of their adult children or somebody, so that they have the option to start using this whenever they want to, but we're getting out ahead of the issue.
This is just kind of a hybrid strategy when we think I don't know that we're going to make it through that 5-year look back period, but we do have a little bit more time. Okay. Sorry.
So other kinds of exempt assets would be home improvement costs. If you've been waiting to put a new kitchen in for 10 years and you've got a spouse that's about to go into long-term care, take some money, hire a contractor, put some equity into your home. If you need to pay down some personal debts, if you got a spouse going into long-term care and you've got money in the bank, pay some credit card debts down. So prepay a funeral contract or a memorial contract. Get a new car if you've been putting it off. So these are things you can do with your money that are not going to count against you if you're in a crisis. So let's look at an example of a couple we call Mark and Lois. Lois has Alzheimer's disease, and she's transitioning into a memory care unit for the first time. She's been living at home, and it's now time. Mark knows that he can't continue to take care of her. She needs to go into long-term care, but they have not done any advanced planning. They want to preserve as many assets as possible for Mark and to supplement Lois's care as long as she's alive and in the nursing home. So what can we do? Well, the first thing we're going to do is apply for Medicaid as soon as Lois enters into skilled nursing. And that's going to help us create what we call a snapshot of assets to determine eligibility. We know we're probably not going to qualify at that point. They're going to have too many assets, but that's going to give us the snapshot date where Medicaid says, okay, now these are the assets we're looking at to determine whether or not Lois is going to qualify for Medicaid. Let's say in Mark and Lois's case that their total assets are about $750,000. They've got a home worth $250,000. They've got $350,000 in Lois's 401k. She worked and contributed to that. And then they've got about $150,000 between their checking and savings and brokerage accounts. So a total of $750,000. Do we have to spend all of that down to get her qualified for Medicaid? No. What we're going to do first is we're going to set the house aside. Mark can still live at home. We don't even need to think about that $250,000. That's money that's not going to count against Lois. Set it over there. So now we've got a $500,000 problem. She's got a 401k and they've got cash, and that's going to be an issue. Now, in this illustration, I'm going to think about the cash separately from Lois's 401k. We're going to look at that $150,000 and say that $75,000 of that is Mark's. Remember, he gets to keep half, and $75,000 is Lois's. Mark is safe. We don't need to spend down his $75,000 because it's already under that $130,000 cap. And then Lois needs to be spent down to $2,000. So that's $73,000 from Lois that we got to find something to do with. With her portion, we're going to go ahead and pay some medical bills. We're going to pay off the credit card debt. We're going to purchase a burial contract for her. We're going to put some money into the new kitchen or new bathroom or some new furniture at the house, maybe put a new roof on if it's been a while. We're going to get her a care manager contract, and we're going to pay some legal fees. But what about that 401k? We got $350,000 here that we don't want to have to lose. Is that also going to be subject to a spin down? Well, we can do something pretty cool with your retirement funds. In this case, we're going to take Lois's entire 401k and we're going to purchase a specific kind of annuity for Mark. And it's going to turn that $350,000 asset that counts entirely against Lois into a stream of income for Mark that doesn't count against her. We're going to be able to save 100% of that money. It's not going to need to get spent down. In this particular case, and we've had similar situations here, we've got clients who have around $750,000 in value, and we maybe had to spend $15,000 to $25,000 of it before we got the spouse qualified for Medicaid. So even in a crisis, there's often things we can do to protect a lot of what you've saved for together without having to spend it all down in long-term care costs and qualify for Medicaid instead. So this will be kind of the last slide, and then we want to take some questions if we can, and that's kind of up to Matt if he thinks we have time, because we're right at 6:40. There are other benefit programs like SSI and VA. We can talk about qualifying for those as well. The rules we talked to this evening are specific to the Medicaid program, but we often help people qualify for a variety of benefit programs as well. We're creating special needs trusts to help people qualify for other kinds of means tested benefits besides just Medicaid. So there's SSI and vocational rehab and governmental housing. Those kind of things might be available as well. And then there's a variety of strategies we haven't even touched. There's a lot of different things we can throw at a crisis Medicaid situation. But the best option is always to plan ahead. That's the further ahead you plan, the more options you have and the cheaper it is. Okay. Now we'll stop talking for a minute. I'll even stop screen sharing so you can see our beautiful faces even more.
Beautiful shining faces. Yeah. And if you don't have questions, I'm just going to fill the space with something else I wanted to talk about.
Yeah, but
like gardening. No, not really.
We'll stop talking for a minute. Matt, if you've got any questions you want to ask, or if anyone else does, we're available.
One quick question. All this, it sounds great, but it's a lot. And so if I come to you guys and say, can you all help me know where to spend this and that, or somebody, or what's the best tracking system for somebody to know that they need to do all of this? And then also another question, I heard Oklahoma expanded Medicaid. Does that change this at all, or is that a totally different situation?
That just means we have more, the state has more money to spend on it, but the rules are the same.
Okay.
We didn't change the rules for qualification. We just changed the amount of available resources. Now, it's in the state's interest not to give you Medicaid. So even though the state has more Medicaid dollars, there's an incentive built in not to get people qualified. So they try hard to keep people from getting qualified, because any money at the end of the year that they haven't spent on Medicaid, they get to fold back into their general budget.
Oh,
So it's, so your question, Matt, was really good. Two things should trigger you to be thinking about this. Number one, if you or your partner or your parent has a chronic illness, you need to come talk to us or some elder law attorney. And if you're already going into the nursing home, it's going to happen sooner or later. You know, you're within a month or two if somebody needs long-term care, you're in crisis planning, and we need to talk to them too. But the existence of a chronic illness should put you in plan ahead time. Now, you're right. We covered a lot of information. Tonight was like drinking from a fire hose. Okay. When we meet with clients to unpack their particular situation, this is a slow, methodical, specific to you conversation. And the plan that we come up for you is unique to you and your family and your assets. There's not a one size fits all here.
perfect. So it must mean it's the implementation must feel pretty natural in terms of knowing what you need to do next.
Right. The point of tonight, the real takeaway for you is to know that there are things available. There are solutions available besides going broke.
Mhm.
If you're afraid of losing all of your savings because of this dumb disease, we can help. That's the takeaway.
Perfect. Anybody else have any questions? I keep muting myself. You can hear my dogs. Apologize. Go ahead, Anka.
If my husband and I have revocable trust, we have power of attorney advanced. Well, the whole thing is in place.
Good.
So if there's money in the account, bank account, that's a revocable trust. So what you are saying that we should put our Social Security, our pension, everything should be made payable to trust versus being paid to us. Am I correct to understand that?
So what I'm hearing you say is like, those are income streams that you have, right? Your Social Security and your pension. So you don't necessarily need them to be made payable to the trust. You probably have a bank account and that should be owned by your trust.
Yeah, bank account is a trust account.
But
Yeah.
the difference here is that a revocable trust, if you and your husband have revocable trusts, that doesn't protect anything from a Medicaid spin down.
It will avoid probate. And it's going to provide some asset protection for your kids if you've created beneficiary trusts in your revocable trust planning. But if you're just thinking, you know, how do I make sure that the income we're receiving monthly goes into the trust? Well, it does that when you deposit it into the bank account that's owned by your trust. If you're asking, is that going to mean that those assets are not counted on an application for Medicaid? No. I mean, you're still going to have to report that income from a revocable living trust.
Yeah.
But
And I know this is sometimes a disappointing answer to people. A revocable living trust